Tantor Audio, a division of Recorded Books, presents A Matter of Interpretation, Federal Courts and the Law, by Antonin Scalia. Foreword by Amy Gutman. Narrated by Christopher Grove. Preface. The rule of law is essential to constitutional democracy, but its implications for how judges should interpret the law are complex and contested, as evidenced by Justice Antonin Scalia's elegant essay and the respectful but challenging responses to it by Professors Ronald Dworkin, Mary Ann Glendon, Lawrence Tribe, and Gordon Wood. Together, these eminent legal minds address one of the most important legal questions of our time. How should judges interpret statutory and constitutional law so that its rule is a reality that is consistent with a constitutional democratic ideal? Should the aim of judges be to determine the intent of the legislators who made the law? On its face, this appears to be a democratic aim, to capture the intention of the law's makers, legislators who are accountable to the majority. Justice Scalia offers a powerful critique of this popular idea that judicial interpretation should be guided by legislative intent. A government of laws, not of men, means that the unexpressed intent of legislators must not bind citizens. Laws mean what they actually say, not what legislators intended them to say but did not write into the law's text for anyone, or everyone so moved, to read. This is the essence of the philosophy of law that Justice Scalia develops here in more detail. This philosophy is called textualism, or originalism, since it is the original meaning of the text, applied to present circumstances, that should govern judicial interpretation of statutes and the Constitution. The idea that the law is what the words that constitute it mean is, of course, too simple. Most words are open to multiple interpretations. To say that laws are what their words mean would be to leave the meaning of most laws unacceptably ambiguous. The complexity of figuring out what laws mean should not prevent us, as it does not prevent Justice Scalia, from eliminating indefensible responses to the challenge of interpreting apparently ambiguous laws. Justice Scalia criticizes two alternatives to textualism: judicial decision-making according to subjective intent, and judicial creation of a living or evolving constitution, as indefensible ways of interpreting or failing to interpret the law. But he also goes well beyond criticism. He develops and defends the merits of his philosophy of textualism. Justice Scalia shows that textualism is not wooden, unimaginative, or pedestrian, and least of all, is it boring? Textualism is not strict constructivism, although, he says, strict constructivism would be better than non-textualism. Words do have a limited range of meaning, and no interpretation that goes beyond that range is permissible. Scalia's respondents take up his challenge to show what could possibly be wrong with the commonsensical view that judicial interpretation should be guided by the text and not by intentions or ideals external to it, and by the original meaning of the text, not by its evolving meaning over time. The questions raised by Justice Scalia's commentators are of two kinds. What do judges committed to textualism do when the text is ambiguous? More critically, why should judges desist from invoking moral principles and other non-textual aids to help interpret the law when the text itself is an inadequate guide? Justice Scalia anticipates both challenges in his essay, and he also replies to them in his response. Justices must do their best to figure out, first, the original meaning of laws, and, second, the practical implications given new contexts for those original meanings. In most cases, judges will be successful in so doing. Originalism helps specify textualism and helps judges arrive at definite interpretations of the text even when the words are ambiguous. There is plenty of room for disagreement as to what original meaning was, and even more as to how that original meaning applies to the situation before the court, Justice Scalia writes. But the originalist at least knows what he is looking for, the original meaning of the text. Often, indeed, I dare say usually, that is easy to discern and simple to apply. Sometimes, though not very often, there will be disagreement regarding the original meaning, and sometimes there will be disagreement as to how that original meaning applies to new and unforeseen phenomena. But the disagreement of views about interpreting the law represented in this volume ranges much further than resolving ambiguity about original meaning or uncertainty about how to apply original meaning to new and unforeseen phenomena. Professors Wood, Tribe, Glendon, and Dworkin also take issue with other claims that Justice Scalia makes on behalf of textualism. They question whether textualism, as Justice Scalia understands it, is the legal philosophy that is most defensible or consistent with democratic values. All the commentators concur with Justice Scalia's critique of interpreting the law according to either subjective legislative intent or a judge's favorite moral philosophy. But they suggest other alternatives, including some significantly different versions of textualism that are apparently defensible and democratic, even if not definitive options. They argue that these alternatives do not suffer from the same devastating flaws as the interpretive strategies that Justice Scalia criticizes. Professor Wood joins Justice Scalia in worrying about the tension between judicial lawmaking and democracy. Judges, he agrees, should be interpreters, not makers of the law. But Professor Wood, whose area of expertise is American history, also worries that Justice Scalia underestimates the degree to which judicial lawmaking is part of the very constitution of American democracy, albeit an extremely controversial part. Thomas Jefferson struggled unsuccessfully to end the eccentric impulses of whimsical, capricious, designing man, and to make the judge a mere machine. But not all, or even most, of the Founding Fathers shared Jefferson's aims, nor did the design of the judiciary follow Jefferson's plan. According to Professor Wood, the courts became independent entities whose relationship with the sovereign people made them appear to have nearly equal authority with the legislatures in the creation of law. The transformation was monumental. If Professor Wood's interpretation of American history is correct, then the blurring of legislative and judicial matters may be the rule rather than the exception for post-colonial America. Professor Tribe defends a version of textualism that helps explain why this blurring may be necessary. He doubts that judges, historians, or anyone else can discover enough about the law to render decisions in many cases by interpreting the text only in the way that Justice Scalia recommends. Yet Professor Tribe also wants to prevent judges from legislating their personal preferences or values under the guise of constitutional interpretation. To prevent judges from usurping democratic authority, he suggests a strategy quite different from Justice Scalia. One must concede, Professor Tribe says, how difficult the task of constitutional interpretation is, avoiding all pretense that it can be reduced to a passive process of discovering rather than constructing an interpretation, and replace such pretense with a forthright account, incomplete and inconclusive though it might be, of why one deems his or her proposed construction of the text to be worthy of acceptance, in light of the Constitution as a whole and the history of its interpretation. Professor Tribe therefore takes up Justice Scalia's challenge by doubting that any defensible set of ultimate rules of interpretation exists. Insights and perspectives, yes. Rules, no. Judges can still know how not to interpret laws, but they must of necessity look outside the Constitution itself for guidance, as must all who are authorized by the Constitution to interpret it and duty-bound to adhere to its provisions. The Constitution's written text has primacy and must be deemed the ultimate point of departure, and nothing irreconcilable with the text can properly be considered part of the Constitution. Nonetheless, there is nothing in the text itself that proclaims the Constitution's text to be the sole or ultimate point of reference. And even if there were, such a self-referential proclamation would raise the problem of infinite regress and would, in addition, leave unanswered the very question with which we began. How is the text's meaning to be ascertained? Professor Glendon focuses on a neglected topic raised by Justice Scalia's critique of extending common law habits to statutory and constitutional law. The merits of common law habits apply to the realm of the common law. Many of our interpretive ills are due to the survival of common law habits in the word of enacted law, Professor Glendon writes. But it ought to be said that those habits were good ones, even if ill-adapted to statutory and constitutional interpretation. It is cause for concern, therefore, that they seem to be deteriorating. Stare decisis, by protecting the power of precedent, lends stability to the expectations of citizens. There could be far worse, Professor Glendon suggests, than a Supreme Court that followed common law methods, in the sense of attending in each case to providing a fair resolution of the case at hand, mooring that decision in text and tradition, fairly exposing its reasoning processes, and providing guidance to parties in future cases. By contrast, Professor Glendon asks us to consider a court whose rulings look less like the reasoned elaboration of principle than like the products of majority vote. At times the court appears just to be lurching along in irrational and unpredictable fashion, like the monster in the old version of Frankenstein. This kind of court would give us far more to fear, Glendon vividly argues, than one that followed common law patterns of principled building upon precedent. Professor Dworkin defends a different version of originalism from Justice Scalia's. The idea that distinguishes Professor Dworkin's version from that of Justice Scalia's is that key constitutional provisions, as a matter of their original meaning, set out abstract principles rather than concrete or dated rules. If so, then the application of these abstract principles to particular cases, which takes fresh judgment, must be continually reviewed, not in an attempt to find substitutes for what the Constitution says, but out of respect for what it says. Professor Dworkin argues that this interpretive strategy is both true to the text and principled. Why, he asks, shouldn't the framers have thought that a combination of concrete and abstract rights would best secure the evidently abstract goals they set out in the preamble? Why shouldn't we think that wise statesmen would realize that their views were not the last word on the subject? Moreover, Professor Dworkin argues, there was no generally accepted understanding of the right of free speech on which the framers could have based a dated clause, even if they had wanted to write one. When the debate raged over the Sedition Act of 1798, no one supposed that the First Amendment codified some current and settled understanding, and the deep division among them showed that there was no settled understanding to codify. The division among the contributors to this book may not be as deep as that between the authors of the Sedition Act and their critics, but there is certainly no settled answer among them to the question of how judges should interpret statutory and constitutional law. Although it is up to each to adjudicate this disagreement, Justice Scalia's respectful yet spirited response to his commentators will undoubtedly increase our understanding of the merits of alternative answers and heighten our awareness of the stakes for all American citizens. This book originated in an invitation by the University Center for Human Values at Princeton University to Justice Scalia to deliver the Tantor lectures, and to Professors Dworkin, Glendon, Tribe, and Wood to offer commentaries on them. We are all thankful to the Tantor Trust for their generous support of the Tantor lectures and for the University Center for Human Values for hosting the lectures each year. We are especially grateful to Mrs. Grace Adams Tanner and the late Mr. Obert Clark Tanner for endowing the Tanner Lectures, and to Mr. Lawrence S. Rockefeller for endowing the University Center for Human Values. As part of the University Center for Human Values publication series, this book conveys our mutual dedication to giving voice to perspectives that challenge conventional ways of thinking, and thereby contribute to our reflecting more deeply and broadly about issues of great human significance. Amy Gutman, Lawrence S. Rockefeller University Professor, University Center for Human Values, Princeton University. Introduction to the New Edition. Akhil Reed Amar. Like Socrates long ago, Antonin Scalia loved to argue. As with the best Socratic dialogues of old, the book you are now listening to overflows with opinion, not just assertions of its provocative protagonist, but also contentions arrayed against the provocateur's position. To his great credit, Justice Scalia invited pushbacks to the views he laid out in the main text of this book. Several towering scholars of his era, Gordon S. Wood, Lawrence H. Tribe, Mary Ann Glendon, and Ronald Dworkin, rose to the challenge with sparkling responses that did not merely say, Amen. Repeatedly, these response essays also or instead said, but, not quite, and even, no. In this spirited Socratic exchange, it was only fair that Scalia had the last word, by way of rebuttal. This was and is, after all, his book. The justice has now passed away, and thus cannot have the last word in this new edition. When approached by Princeton University Press to write a short introduction, I insisted on two conditions. First, that I be allowed to offer blunt counter-arguments to the justice's essays, because he deserved and deserves nothing less. He would not want punches pulled. Second, that this edition's last word go to someone who could stand in the justice's place, in loco Scalia, so to speak, to respond to anything punchy that I might write. I suggested that the new closer should be an accomplished apostle of the justice, but that he or she need not parrot Scalia 1.0 on every point. Perhaps the justice himself, were he still alive and at the peak of his analytic powers, might have wished to revise certain initial formulations so as to parry or absorb the latest round of critique. I can think of no Scalia protege more fitting to discharge this responsibility than Professor Stephen Calabrese, who in the early 1980s co-founded the Federalist Society, with the strong support of then Professor Scalia, and who went on to clerk for the justice in the very period when many of the ideas of this book were brewing in the boss's brain. Back then, I was both a Scalia admirer and a Scalia skeptic, while Steve was a true blue Scalia disciple. Since then, our positions have ripened with age, and we continue to talk and even argue about Scalia. The justice would be pleased. The only thing worse than being talked about, noted Oscar Wilde, is not being talked about. And the only thing better than being talked about, Justice Scalia might have added, is being argued about. So, let the latest round of arguments begin. First, a tip of the hat to the great man. This book features a powerful critique of a certain kind of statutory interpretation that loomed large in the 1970s and 80s and that no longer dominates the federal bench, in large part thanks to Scalia himself. Federal judges today pay more attention to statutory text, the words that the legislature actually enacted, as opposed to legislative committee reports and other dubious forms of legislative history. Although Scalia at times emphasized isolated words too much over the larger purposes and general structure of particular statutes, he was right to remind us all to focus first and foremost on the text of the laws themselves. In the field of constitutional interpretation, This book also deserves credit for championing the importance of originalism, an interpretive methodology focusing on what a given patch of constitutional text meant when it was originally enacted. For example, what did the Article 3 words judicial power mean in 1787 to 1788? What did the ratifiers of the 14th Amendment in 1866 to 1868 understand themselves as doing when declaring that states must honor the basic privileges and immunities of American citizens? Originalism is not a uniquely conservative jurisprudence. The greatest judicial originalist of the 20th century was a crusading liberal, Hugo Black, Franklin Roosevelt's first pick for the Supreme Court and a driving force during the liberal judicial heyday known as the Warren Court. Today, some of the best originalist work in the legal academy either comes from avowed liberals or supports various liberal outcomes. Alas, Scalia's particular brand of originalism in this book was problematic. In one notable passage, he heaped scorn upon the philosophy which says that the Constitution changes, that the very act which it once prohibited it now permits, and which it once permitted it now forbids. But consider the following. At one time, a certain person, let's call him Smith, was prohibited from being president, and now Smith is permitted to be president, for the simple reason that Smith was once 34 years old, and thus ineligible. A president must be 35. But now Smith is 36. As this laughably simple example proves, the text itself may interact with the world outside the text to generate different results at different times. Now apply this insight to the death penalty, one of Scalia's hobby horses. How, Scalia asks, could anyone think the death penalty is now unconstitutional, given that it was clearly constitutional at the founding? Simple. This punishment was at one time highly typical and today is becoming rare. In a word, unusual. And the Constitution's Eighth Amendment expressly prohibits cruel and unusual punishments. If you don't buy this argument as it regards the death penalty across the board, just consider it for certain subcategories of cases. For example, the death penalty for mere pickpockets or for some juvenile offenders. This, in a nutshell, is Dworkin's textual counter-argument to Scalia, and Scalia had no clean textual response, only obfuscation and evasion, albeit of an impressive rhetorical sort. Scalia's best, if generic and conclusory response was that the Constitution's whole purpose is to prevent change. This whole purpose passage was essentially making a historical and structural argument, and an enormous one at that, as noted in passing by Tribe. But Scalia presented zero historical evidence to back up this totalizing claim, and several of Scalia's closely related historical claims met with some skepticism and uneasiness from Wood, a preeminent professional historian. Preventing change might seem a self-evident all-purpose purpose for a pre-Vatican II Catholic of a certain sort, but it is far from clear that this was the only purpose of the Constitution, or its framers and ratifiers, Enlightenment experimentalists who likely aimed not just to prevent certain kinds of change, but also to channel other kinds of change in certain ways, and to keep a constitutional conversation going in the centuries to come. The death penalty cases that so exercised Scalia were almost always cases involving states. For any true careful originalist, these were not simply Eighth Amendment cases rooted solely in an 18th century ban on cruel and unusual punishments, but rather 14th Amendment cases whose proper textual foundation involved privileges and immunities and due process rights that no state could lawfully abridge or deny. And one major purpose of the 14th Amendment, as squarely understood and embraced by its framers and ratifiers, was to keep outlier states in line with national norms. For example, by reining in cruelty in a handful of states, especially the Deep South, cruelty that was particularly outlandish, unusual when judged by national standards. In this book and on the court, Scalia too often failed to read the Constitution's text all the way to the end, to give due weight to its transformative amendments added by post-founding reformers. This lapse was especially unfortunate, given that so much of American constitutional law revolves around the 14th Amendment. By discussing the language of the 8th Amendment and the 8th Amendment only, even though almost all the major punishment cases of his lifetime involved states, which handle the vast bulk of criminal punishment in America, Scalia in this book and on the court was mainly looking under the wrong textual and historical lamppost. When pressed on this key methodological point by Professor Tribe in this volume, Scalia's skimpy response was that repeals by implication are disfavored. But the justice offered no analysis of whether this soft statutory interpretation maxim, which in certain contexts sensibly applies to certain kinds of laws enacted by legislatures that regularly sit for long stretches and pass detailed new standalone statutes, makes similar sense when applied to the United States Constitution. After all, the Constitution, quite unlike many a statute, is a strikingly compact set of words that at times speaks in broad strokes, a multi-generational text in which amendments have only sporadically been added in ultra-terse patches, and have been added at the end of the document with no detailed instructions about how extensively to reinterpret earlier clauses in light of later amendments. Nowhere does this intergenerational text itself say that repeals by implication are disfavored, or anything close to that. Consider on this point the 19th Amendment, on women's suffrage. This amendatory text does not explicitly say that women have a right to run for president even if a state law tries to limit ballot access to men. At the founding, Article 2 used the words he and him to describe the president, and states did in fact bar women from running for office. If these founding words and founding practices were not repealed by the letter and spirit and gravitational pull, an underlying logic of the 19th Amendment, then can a state today refuse to allow a woman to run for president? Is that what Scalia would say, on reflection? Or if, instead, he would say, and we should say, that the 19th Amendment does in fact do the proper repealing work, and that women today do have a right to run for president no matter what a state might try to do. Isn't this a species of repeal by mere implication, given that the amendment does not quite say this in a detailed and explicit way? In any event, the 14th Amendment did not repeal earlier constitutional understandings and provisions merely by implication. Rather, the amendment transformed the basic constitutional rules with explicit and emphatic language that Scalia never carefully analyzed, language that came with detailed historical understandings and meanings rooted in the 1860s and not merely the 1790s, understandings and meanings that Scalia consistently ignored or pooh-poohed. No state shall make or enforce any law that shall abridge the privileges or immunities, that is, the basic and foundational civil rights, of citizens. The original public meaning of these 1860s words prohibited states from imposing cruel and unusual punishments, and any serious originalist must ponder what usualness meant in the 1860s. And not just what it meant in the English Bill of Rights of 1689 or the original American Bill of Rights a century later. The need to read the Constitution as a whole and to find meaning in its larger patterns and structures by reading between the lines is not limited to the special intergenerational issues raised by the Reconstruction and Progressive Era amendments. Sensible originalists understand the constitutional significance of federalism, separation of powers, and the rule of law, even though none of these overarching structural principles appear in any explicit patch of text. We must read between the lines to understand the whole, for the Constitution itself.
Sample complete. Ready to continue?